Welcome, everyone. I'm just going to allow attendees to trickle in for about a minute or so, and then we'll begin. Okay, let's get started. Welcome, everyone. Thank you for joining us for today's commercial lease negotiation webinar. Before we start with the webinar, I will cover some housekeeping items really quickly. First, we have a simultaneous interpretation in Spanish and Cantonese. So if you would like to listen to this webinar in one of those languages, please click the globe icon at the bottom of the screen and then click on the language you would like to listen to. I'm going to give our interpreters a couple of moments just to translate that. And so then you can click on the globe icon and we will continue with the webinar. Carissa, you can go ahead.
Good afternoon. This is Carissa Duan. I'm the Cantonese interpreter. I'll be giving the language channel instructions. Hello， 大家好。我哋今日喺呢次嘅會議中咧，會提供粵語嘅現場翻譯。如果你係想聽粵語嘅話咧，請登記 Zoom 屏幕右下角個翻譯嘅按鈕，你會見到一個地球嘅圖標。今日你可以揀Chinese。咁啊，如果你係通過智能手機或者平板電腦入到個 Zoom 咧，就通過單擊更多或者屏幕右下角嘅3個點嚟選擇語言，選擇語言翻譯之後咧，再選擇 Chinese， 然後單擊完成 Done。如果你只係想聽傳譯員，亦唔係講者嘅原聲咧，請確保單擊使原聲正音 Mute Original Audio。好，唔該晒。Thank you. Back to you. I'm done.
Thank you so much, Carissa. Our Spanish interpreter will be joining us in a couple of moments, but for people who need Spanish interpretation, para las personas que necesitan interpretación en español, pueden hacerle clic al icono debajo de su pantalla, donde aparece un globo, así pueden escuchar nuestra presentación en español. Okay. So I'll give everyone a moment to do that.
Nico?
Yes.
Sorry, I see the globe, which I shouldn't be. I need to be assigned to a language channel.
Oh, I've got you.
Yeah, thank you.
Perfect. So our Cantonese channel is now open. And you will be able to join the Spanish channel briefly. Okay, everyone. So this webinar is hosted by the Legal Services for Entrepreneurship program that is ran out of Lawyers Committee for Civil Rights of the San Francisco Bay Area. And it is co-sponsored by Oakland Black Business Fund. This webinar will also be recorded and posted on the Lawyers Committee for Civil Rights YouTube channel. If you post a question in the chat box, we will not disclose the names during the Q&A session. So please feel free to use the chat box or Q&A box for questions. Our main presenter will monitor the questions and answer them during the Q&A portion of this presentation. But first, we will have Damon Johnson, Director of Community Relations at Oakland Black Business Fund, present briefly, and then LSC Staff Attorney Julie Gilgoff will provide you all with information on commercial lease negotiation tactics. So I'm going to turn it over to Damon for the presentation. And thank you so much for joining us and co-sponsoring this webinar.
Thank you for having me. It's really exciting to be partnering with LSE and being a part of this great work. So just to give you all a very quick overview of Oakland Black Business Fund, who we are and sort of how we started. Let's going over to our first slide here. I can start. So we are a Black-led grant-making program. We started in 2022, right after the murder of George Floyd, where we saw that with the civil unrest that was happening in Oakland, that rightfully so, people protesting, people showing their displeasure with what happened with George Floyd. We saw damages to storefronts that were Black-owned storefronts as a result of the civil unrest that happened after the peaceful protest. We saw that was, you know, once you lose these sorts of businesses, once you lose your Main Street and you lose, you know, the people that are your Broadway, your 14th Street, your up and down the block retail businesses, once those boards go up on those windows, like there's a higher chance for businesses of color to not open back up. So we started raising funds to help in the repair of those businesses and make sure that any closures were temporary short-term closures, and we were able to help businesses get back on their feet right away. As we raised more and more money, we saw that it wasn't just about damages with businesses. There's a lot of technical assistance that's necessary. There's a lot of missing of the memos when grants like PPP loans and resources come into the community. So we wanted to be a resource for businesses in our community. So next slide, please. And our successes over our past 2 years, we've raised over $600,000 that we've put back into the community. We're volunteer staffed and run, so there's no overhead. That all that money went back into the community. We've had over 2,500 donors, 25 Oakland neighborhoods served, 450 applications received, and over 150 businesses to this date have been funded. So we're very excited for 2022, where this is our third year of activity, which is hard to believe. Next slide. And so we're updating our goals. So what we did in the past is we were reacting to business pain points. So businesses would come to us, of course, with damages and say, hey, I need to fix my window, or there's graffiti on my storefront. I need to be able to get back up and running, or, you know, I need help with marketing, or I need assistance in a certain way. And we would reach out to everybody on a case-to-case basis and find a way to support them with what they need. Moving forward, we found that instead of being reactionary when there's a storm and trying to sort of fix a flood or fix damage, we want to help strengthen businesses so when the next storm comes, these businesses are prepared. So we're shifting our model to work with organizations like LSE for, you know, legal advocacy and workshops like the one you're in right now, business formation help with having financial relationships with CDFIs in the community, bookkeeping, education, tax preparation, these sorts of things that every business needs when they're starting up, and it's essential for them to have those sorts of relationships. All right, next slide. So again, our model in 2020 and 2021 was to focus on the technical assistance and being very reactionary and you know, looking for business pain points. And then the next slide will show you, like, moving forward, really going to look at those essential pieces. And on the next slide, we'll see that it's not even that really big of a change. So I don't even need the next slide, but that's our next move is we're going to look and make sure that the businesses that we work with are able to count on certain essential needs that every business should have and not go without. So that's what we do. This is, again, a very exciting partnership to engage with, because the workshops that LSC puts together are right in line with the sort of business essential education and needs that we want to pass along to the Oakland small business community. So thank you so much for having me, and I'm looking forward to this, and handing it right off to Julie.
Thank you, Damon. Thanks for co-sponsoring today's webinar, and thanks to all the participants for attending. I'm going to share my screen and get started. So I'm one of 2 staff attorneys at Legal Services for Entrepreneurs, which is a program of Lawyers Committee for Civil Rights of the SF Bay Area. Legal Services for Entrepreneurs provides free legal services to eligible small businesses in the Bay Area. And I'll give information at the end about how to apply for our services, as well as my personal email address. And, speaking on behalf of all LSC staff, it's just an honor to serve Bay Area small businesses. We wouldn't want to live here without you or work here. And we consider it our job and mission to help you thrive and continue to operate. So let me make this a full screen and we'll get started. So today's agenda, I'm going to go over some of the details from the moratorium that protected commercial tenants from eviction. And at least in San Francisco, there's still a forbearance period that outlines the amount of time you have to repay all the back rent that accrued during the pandemic. We'll go over some key lease provisions to look out for when you negotiate with your landlord rent repayment plan, as well as negotiation strategies when you speak to your landlord, and also what to be aware of in case you're served with an unlawful detainer, which is California's way of saying an eviction lawsuit. So the commercial eviction moratorium expired on September 30th in most cities and counties. So now what? What does that mean for you? In San Francisco, at least, there is still a forbearance period in effect. So depending on the tier of business, which means how many full-time employees you had as of November 2020, your tier is determined. And this outlines how much time you have to repay all the rent that accrued from March 2020 through September 2021. And for tier 1 businesses with 10 or fewer full-time employees as of November 2020, you have 2 years from the expiration of the moratorium. So that means September 30th, 2023. You have all that time to repay the back rent. And if your landlord asks for that money sooner, you should just know your right to tell them the time frame that you have to repay your rent. And our organization, LSC, we provide template rent repayment plans. So if you need help negotiating with your landlord, regardless of the city you live in, we'll send that template form as a follow-up, both in English and Spanish, and also Cantonese for participants today. And we're happy to help you negotiate with your landlord, but in certain circumstances, it's also advisable to begin the conversations yourself, and I'll get more into that later. In San Francisco, there's an additional protection. It's called the Rebuttable Presumption. And this means that for the months during the pandemic when you were required to be completely shut down, and this may be because you had, you operate a nail salon or massage salon, you couldn't be open by government mandate. And so for those months that you were ordered to be completely shut down, you shouldn't have to pay rent. And that will be upheld in court if your landlord tries to sue you for the back rent. There always were still risks of eviction in San Francisco, even during the moratorium period. The landlord could still sue for nuisance and other breaches of the lease agreement. Many people's leases expired, and that was, a looming question. Could landlords evict you because your lease expired? But definitely one important message that we have to deliver is that as of October 1st, 2021, after the moratorium expired, you are expected to pay full rent going forward. And we know how difficult that is for many of you who are still operating at limited capacity. And so this is just yet another area for negotiation with your landlords, to talk about that base rent that may have been reasonable before the pandemic, but because you're still operating at limited capacity and because you're now expected to make monthly payments towards repaying the back rent, that may no longer be feasible. And so that is an additional resource that we'd like to distribute, is a lease amendment to renegotiate your lease terms in this environment. And I see there's a message in the chat. Nicole was reminding you to please post your questions in the Q&A box or just in the chat, which I'll be reviewing throughout the presentation. And I want to be interrupted, so please feel free to ask your questions at any time. In Alameda County, there is no forbearance period. So once the moratorium expired, September 30th, 2021, full rent was due the day after, as well as all the back rent that accrued. We haven't seen an uptick in evictions that we expected, which means that landlords are, some landlords are aware of the impossibility to pay all the back rent that accrued during the pandemic. Many landlords are offering not just rent repayment plans, but also rent abatement, rent forgiveness for at least some of the months or during the pandemic, or possibly 50% of the rent. So you should just feel empowered to ask for what you need so that your business can survive during this time. In the city of Berkeley, I believe that the moratorium is still in effect, and when it expires, businesses will have 12 months from the expiration to pay all the deferred rent, regardless of what tier you're in. They don't have a tiered system, so all businesses have 12 months after the expiration to repay the rent, which makes a lot of sense given the limited capacity that everyone's functioning in. And we wanted to mention, as well as our services, the Alameda County Court Self-Help Center offers phone and video consultations, as well as a live chat feature if you are served with an unlawful detainer summons and complaint. And Alameda County Bar Association offers referrals to a private lawyer for sliding scale, but do first apply to our services, since we offer our legal services free of charge to eligible small businesses. So in this section, I wanted to offer some tips for negotiating with your landlord. Some small businesses that come to us, they do have a working relationship with their landlord. And in those circumstances, we suggest that the tenant yourself continues the conversation rather than asking an attorney to become involved. Sometimes that escalates the conversation, and an attorney, it still is helpful to consult with us so that we could provide step-by-step, coaching on what we think of the landlord's offer and what to counter offer in response. So the first step in any of this is to review your lease. You want to know the date that your lease expires. You want to know the monthly rent base. If your lease has expired, you're going to want to know, are you considered a month-to-month tenant, and are you considered a holdover tenant? So your lease will outline all those provisions, and we're happy to help you look through your lease as well. And don't forget to, when you look over your lease, to look at the exhibits, appendices, addendums. Many times there is an original lease, and if you've ever exercised the option to extend your lease, the follow-up documents won't have as much information. So it's the original leases that contain a lot of the important information. And likewise, if you sublet from somebody, you're going to want to ask the original tenant for their version of the lease that contains the provisions that are now relevant to you. If you don't have a lease, many people come to us with just a verbal agreement, or their lease expired and their original lease didn't have that provision of what's a holdover tenant. So we're going to want to help you look at what rent have you been paying? Has the landlord cashed the checks? Have they asked for an increase? And in what way do you communicate? So it's these actions rather than the written document that we'll want to look at to ascertain the terms of your lease, of your oral lease. And you're going to want to keep an eye out for common area, shared expenses, camp fees. When we're talking about all the money that's due from the moratorium, during the moratorium period, many tenants will contest that they should have paid full camp fees since there was no common spaces that were even open during that time. The landlord was incurring less expenses in janitorial services and in cleaning. So they shouldn't be charging full camp fees. That's just one option as a way to negotiate and get your landlord to come down on what he's asking for. The rent could be reduced if you couldn't access the building during that time, either because of government mandate or because the building was shut down. If the landlord cut off any services during that time. And you should also just look out for provisions that outline that the landlord won't be liable for these sort of disruptions. In general, though, there's something called the implied covenant of quiet enjoyment that applies to all commercial tenants. It doesn't need to be written into your lease. You don't even need to have a lease. And this just guarantees you the right to enjoy the commercial property that you're renting, and the landlord can't disrupt that by, saying that you can't enter the space. So that is a very, viable defense, regardless of the city you live in. The other implied warranties, like the implied warranty of habitability, that's a guarantee for residential tenants in your homes if you rent, that the space needs to be habitable. The landlord has to maintain that habitability by making certain repairs. In commercial leases, there's not as many protections, and you just want to see what's written in the lease document itself. So again, when you review your lease, and this also, for those of you who are moving into a new space, you'll want to negotiate the inclusion of a force majeure clause. And if you have that on your lease, that's really advantageous, because this literally means an act of God, and it may be interpreted to mean that something like the pandemic or a natural disaster, something that was completely out of your control, it's a supervening event that prevents the lease obligations from going forward, and therefore you shouldn't have to pay rent during the time that you were affected during the pandemic. So that's a legal argument, and it's a really valuable provision to look out for and to include in any future leases. The commercial frustration of purpose defense is available statewide. And so even though San Francisco has its own version that's called the Rebuttable Presumption, anyone who lives in California should make that argument to your landlord that if you were required to be completely shut down, then for certain months, then you shouldn't have to pay any rent during those months. And I included the example of a restaurant, but if you were allowed to open at limited capacity or move your services outside, for example, instead of indoor dining, that doesn't apply to you. So it only applies if you were required to be completely shut down during certain months. For buildings with multiple commercial spaces, like a food court or shopping mall, you might have a provision in your lease that requires the landlord to maintain certain levels of occupancy. And so you could argue that since the occupancy level wasn't maintained during the pandemic, you shouldn't have to pay full rent. And this is really uncharted territory. So we're seeing some landlords offer complete forgiveness during the months of the pandemic, or a certain percentage. We're seeing landlords offer a new base rate that might be based on your percentage of monthly earnings rather than an amount that's not viable any longer. And you always want to explain your situation, especially for those of you who have a working relationship with your landlord. That was required under the moratorium. You had to continue to explain your financial hardship. That doesn't really exist now that the moratorium's expired, but just make sure they know if you got sick during that time, if a family member got sick, and what your reasons were for not operating or not even opening in some cases. Some other negotiation advice includes make an initial ask that's better than what you might settle on. So if you know that the maximum amount that you're willing to pay is $40,000 in back rent, you might want to start with a lesser amount, like $20,000, to make your landlord feel that you're going to meet somewhere in the middle and you have a better chance of getting what you want. Bring up any lasting moratorium protections, especially if you're in San Francisco or Berkeley. Those are two of the cities that still have lasting protections, like the forbearance periods. And then you might want to point to some undesirable behavior of the landlord if they haven't been negotiating in good faith. A lot of your leases contain provisions that mandate that the landlord will engage in mediation with you or arbitration before initiating a lawsuit. So if they're threatening a lawsuit without undergoing those processes or that dialogue, with that constructive dialogue with you, you can call them on that. They may have violated a lease provision, and putting them on the defensive could help you get what you're asking for more. Some other ideas, we went over some of these ideas, but in many cases, landlords are willing to offer a better deal if you are willing to extend your lease, and that might be advantageous for you too. So if you have 2 more years left in your lease and you're really just getting going, many of the businesses we served were completely shut down during the pandemic. They may have just signed their lease. They needed some permits to make some repairs to the property, and everything just got delayed. Haven't even begun earning money on their business. And at this point, they want to stay longer in order to make everything worth it. And so the landlord is often willing to offer this rent forgiveness and rent abatement discounts if the tenant stays longer, so that they know they'll make up some of the lost money. All of you are required to pay security deposits. So many people are, the tenants are proposing use my security deposit towards back rent. And then sometimes the lease requires you to repay it within a certain number of months, but landlords are oftentimes willing to extend that process. And again, we can help at LSE coming up with a rent repayment plan or a lease amendment with a new rent base that you're actually able to pay during this time. And I'm going to check, I see there's a question in the chat. So unfortunately at LSE, we only provide services to tenants. We believe there's an inherent power imbalance between landlords and tenants, which is why we only serve tenants. But I understand the person asking the question is both a landlord and a tenant, and completely understand from the landlord's perspective, they need to make these payments. They're not getting rental assistance, and we encourage you to look at your Office of Small Business in whatever city you're in for any grant programs or loan programs that are available to you, with the hopes that additional funding sources become available in the future. So if your lease term is about to end, consider leveraging a lease extension for a reduction or forgiveness of back rent. You can also ask your landlord if they have received or if they are receiving any assistance, and just say it wouldn't really be fair to receive this sort of assistance and then ask me for full rent. Let's work together to come up with a reasonable solution to make us both as close to whole as possible. Many of our clients are not paying themselves salary, haven't been paying themselves salary for many months or even, a year plus into the pandemic. So just try to work out a solution that makes you both as close to whole as possible. And again, this is what some landlords are willing to do these days, is to convert the base rent to a percentage rent. So we helped a client negotiate a lease amendment that outlined that 15% of monthly earnings would be paid to rent, and that might vary from month to month. So it can't necessarily stay static, but this commercial tenant was required to show all their gross monthly earnings to their landlord on a monthly basis by the 15th of the month, the previous month, and that would determine their next month's rent. And this was only agreed upon for a limited amount of time, with the hope that businesses do get back to operating at full capacity at some point in the future. Let's see, there's another question. The question is, we have a small business in San Francisco. We don't have a lease in place. We've been month to month for a few years. The landlord provided a discounted rent of 25%, which started in 2020, and we're still paying the discounted rent. We're now in negotiations with a potential buyer, and we have an LOI being negotiated prior to alerting our landlord about a potential new buyer. Well, this is great because this is an ideal scenario. Many businesses that we're helping these days want to get out of your lease. It's just not viable. And the best way to avoid a lawsuit is to find a new subtenant yourself or someone to buy your business. So just make sure, think from the perspective, my advice to you is to think from the perspective of the landlord. Does this person have, good credit? And also, is the landlord willing to, formally waive the discounted rent that they owe to you? Many landlords give the impression that we're giving you this discounted rent, for example, 25% that you were paying since 2020. But do they expect that at some point in the future? And that could, even if you try to assign the lease, the new tenant could inherit all that debt. So some landlords are dealing with it in the new lease agreement to make it clear that the new tenant has inherited all that debt, and then it's up to you and the new subtenant together to repay that debt, or is it formally forgiven? So that's just a couple pieces of advice. Make sure it's a viable buyer, and also think about how you're going to address the debt and what you will ask to be forgiven versus what the landlord might claim is still unresolved. The next question is, have you worked with commercial tenants who wanted to buy their building, but the owner is asking for twice the appraised price? How to lower the asking price? We typically don't work with, we refer potential buyers of property to real estate attorneys. So I can't really answer that question, but we at LSE are thinking about policies that could benefit commercial tenants down the line, like the Community Opportunity to Purchase Act, which is now law in San Francisco and does apply to mixed use buildings. So if you happen to be in a building that's getting put up for sale and your business is in a mixed use building, you might be eligible to purchase the building with the help of city funds through the COPA policy. But we're trying to help expand that to be eligible to more businesses. Let's see. Moving on, and please continue to ask your questions as they come up. Let's see if this is a new one. Okay. We're going to go over some viability of defenses. This is still really remains to be seen. We're being told from some antagonistic landlords that defenses like the commercial frustration of purpose only apply once you're in court. They shouldn't apply just in litigation, pre-litigation, like negotiations. And so many are not willing to forgive those months' rent, but we make the argument, if you couldn't get that money in court, why don't you just forgive it now? It's going to save us all the time and resources that initiating a lawsuit entails, and many landlords are willing to bend. It's also unclear, in the next situation that I'll discuss, if a tenant wants to terminate your lease early, legally, the tenant is bound to pay all the rent that's due under the lease until the lease expires. So if your lease expires in 2025 and you want to terminate your lease now in 2022, the landlord legally could hold you accountable for all the months of unpaid rent, even after you vacated, given your keys back. So whenever a tenant comes to us wanting to early terminate your lease, we have to make you aware of that possibility. Many landlords are willing to try to mitigate their damages, which means look for your own subtenant, but it's ideal that you look for your own tenant to take over the lease for you. And we have some forms that we're not going to distribute as follow-up resources, but if you apply for our services, we're happy to help, to give you the forms to sign to make it completely clear that you've moved out, you're giving your keys in, you're surrendering your leased premise, and that now we're asking the landlord to try to mitigate their damages and look for a new tenant, and that you shouldn't be liable for the remainder of the lease obligation. Many tenants who do this, they offer the security deposit. I'm forfeiting my security deposit, which sometimes covers another few months' rent. I've paid, this amount of rent, even though my business is not viable, and just try to convince them that you've really tried your best to make the situation work. There's no other possibility. We often look to see if the tenant signed their lease under the name of an LLC, for example. This could protect your personal assets. So that's another thing we advise people on. If you signed as an individual, then your personal assets, like if you own a car or a home or your personal bank statements, that would be reachable in a lawsuit, as compared to if you signed your lease as an LLC, that would protect your personal assets. So that's just another consideration to think of. And we recently helped a commercial tenant get out of their lease based on a documented disability. And this is considered a reasonable accommodation request under the Americans with Disabilities Act, since these commercial tenants were not able to operate their business any longer because of their worsening disabilities, and the landlord let them get out of their lease without any penalties. That's just another consideration to keep in mind. So Diego is asking a question in the chat. The landlord increased his rent during the pandemic on March 2020. He just increased it again in March 2022. Diego, can I ask you to write in what city your business is located in? In general, in Oakland. So we just need to review the moratorium provisions to see if the March 2020 rent increase, we need to review both your lease to see what it says, as well as the Oakland version of the moratorium to see what it said about rent increases, to see if the March 2020 rent increase can be upheld. My first impression is that if it said in your lease that your rent was going to increase, then that's that's a legitimate rent increase to ask for. But all the rent that accrued from March 2020 until the end of the moratorium period that couldn't be collected at the risk of eviction during that time. And so now it's just a matter of I'm not sure if you paid it. So this is a specific answer specific to your case and situation. So please do apply for our services, and I'd be happy to help you look into it and speak to your landlord if that would be helpful. But in general, there was no statewide prohibition against raising the rents of commercial tenants the way that there was for residential tenants. So there were much less protections, and you just have to look at your local moratorium as well as your individual lease. These are some additional suggestions. Continue to look for resources and updates. In San Francisco, for example, there was just a grant. There's a pilot grant program that was just released. It closed April 1st, but it's very likely to reopen. So continue to look at the website of your small business, your Office of Small Businesses in Oakland, or in San Francisco, it's called OEWD, or Office of Economic and Workforce Development. They have each of these sites, and in whatever city your business is located in, there is an Office of Small Business that collects these sort of resources and consolidates them into one location that you should continue to review for available grants and zero interest loans, which you might be eligible for, which could help your situation. Let's see, with a time check, it's 3:42, and I want to leave some time for questions and answers, but this next part of the webinar is going to go over some of the UD process, what happens if you are sued in an eviction lawsuit, and just timelines to look out for if you do get a summons and complaint or a 3-day notice, and what your options are. And again, please do interrupt me at any time for questions and answers, and I'll also ask again if anyone has any questions. So first off, if you're a sole proprietor of a business, you have the option of filing an answer or representing yourself in court yourself. If your business is an LLC or any type of corporation, and the business was named on the complaint, you need a legal representative to file the answer for you. You can't do it by yourself. LSC is also releasing what's called a pro per guide. So if you are a sole proprietor, and then you have the option of representing yourself, and this guide that we might even send to you as a participant in today's webinar will outline this process and give you sample answers using the state forms. So we'll go over some of that, and then we'll send you the guide as a follow-up. And just as a note, the landlord cannot lock you out of your space without going through this legal process. That would be considered an unlawful lockout, and it would trigger punitive damages, really hefty fines each day that your landlord locks you out. So we've had some clients who the landlord changes the key, or even just tells them, you can't come, I'm holding all your inventory, all your equipment and property until you pay me the back rent. And that's not the way to go about this. So if they're doing that, they might owe money to you for violating the law in that way. So the first step in the initiation of an eviction lawsuit is a notice. So this might be a 3-day notice. It could be a 30-day notice. And in this notice, you have the option to either pay all the rent that's outlined that is due, or quit, which means you move out of the premise. So you have 3 options. When you get a notice like this, you try to cure the breach of the lease by either paying the rent, or if it's for a lease violation, maybe the landlord is evicting you for another reason, you have the option to cure or solve the problem that the landlord is trying to evict you about, or just move out. Or if you do nothing, then the landlord will proceed to initiate an eviction lawsuit. And we think it's worth mentioning all these notice requirements. The notice has to contain this information that's listed on the slide: the date that the demand was served, the name and addresses of the tenants, the total amount of rent that was due, and how the rent should be repaid. And it's worth pointing out the notice requirements, because if there's any defect in the notice, then the lawsuit should be dismissed, and that's grounds for dismissing the lawsuit. The landlord then has the option of reinitiating, and by correcting these defects in the notice, but it will give you more time. So it's worth looking out for these potential defects. I have another question. The question is, usually we're offered a new lease on January 1st of the last year of the lease. We've had our business for 25 years. We're not being offered a new lease yet. Is there a 6-month requirement for landlords to present a new lease or not? What do we do if they do not offer a lease and we want to continue our restaurant in the space? So again, I encourage you to apply for our services. But if you want to look yourself, then you should look in your lease to see if there is an option to extend. And sometimes this is, could be, for example, a 5-year lease with 2 options to extend. So we need to just see what you're guaranteed. Usually, besides looking at how many options to extend is written in your lease, there's always a notice requirement. So how long before the lease expires does each party have to let the other know? On the landlord's behalf, is there the option to extend? And then on the tenant's behalf, do you want to exercise this option to extend? Do you want to stay in the property or not? So that's an abbreviated version of an answer to your question, that there's no inherent right to stay in your space. It just depends on what the lease outlines. And you need to look at your lease, or you could apply for our services to have us help you out. And of course, if you've been there for 25 years, you've been good tenants, you definitely want to reach out to your landlord and ask why they're not offering you this option. If they know you've been good tenants and you want to stay, are they looking to sell? Are they looking for, they don't want to increase the rent to market rate? Just ask them at least what's going on. So in all of these notices that are part of the eviction lawsuit, there's different ways of serving a tenant. Somebody might deliver the notice to you personally. They could leave it with somebody at your business of a suitable age after they've tried to locate you personally, or they could post a copy on the property, usually on the door, and then send a second copy in the mail. So I see there's sure. Just reviewing if there's any more questions. Just want to make the point in this slide that even after receiving the 3-day notice, there's no lawsuit has been initiated at this point, and you're really encouraged to get in touch with your landlord. Just like my answer to the previous question, we are available to help you get in touch with your landlord if they've been abusive or they just are unresponsive. But if you have a working relationship, please ask these questions, right away. If you want to salvage the relationship and continue, is there any way to do so? What do they need to make this working situation? Many landlords, if there's a lot of rent that's owed, just try to come up with a rent repayment plan, a timeline. You can say, the business is getting up and running again, and I'm willing to make monthly payments. Will this work for you to avoid the lawsuit at this stage when one has not been initiated yet? And again, these are notice requirements. The landlord has to include a reasonable estimate of the rent, which is no more or less than 20% deviation from what is actually owed. So if they include a number that's just way off, that's a defect. That's not the beginning of a lawsuit, because they have to issue a new notice that's correct. So after the notice is delivered or served, posted in a conspicuous place, the next step in the actual lawsuit is a summons and complaint. And we're going to outline its similar service requirements. These are the state forms, the UD 100 and the summons form 130 that the landlord has to use. If they don't use these official forms, that's caused to get the case dismissed. And it's really important, if you get a summons and complaint, you have to answer within 5 court days after the summons and complaint is served, or otherwise you may be subject to a default judgment, which means that in the court's eyes, you've accepted liability for all this money, and you have to pay this money without a hearing, without your chance to deny some of the claims made against you or offer defenses. So you always are going to want to answer in a timely manner. If you're the sole proprietor, you have the option of just handing in the form UD 105 without the assistance of a lawyer, although we always suggest that you consult with a lawyer. And these are just more, I'm not going to go over all these details, but these are more details about how the landlord could serve you with your summons and complaint through personal service, substitute service, which is considered leaving a summons and complaint with somebody of a suitable age at your office, or posting it in a conspicuous place like your door, and then mailing the second copy. And again, you have 5 court days. You don't count weekends. You don't count these national holidays that are listed here. And this is an important, if you're not served personally, you will have more than 5 court days to respond. And the way that it works is if the landlord leaves it through substitute service with someone else, not you directly, or if it's posted, the landlord has to mail a second copy to the tenant, and it's considered served 10 calendar days after the second copy is mailed. And after those 10 calendar days, then you have 5 additional days to file your answer. So that's more time if you're not served personally. And so this is the standard form. We've hyperlinked the state form, UD 105. We're also going to send as a follow-up resource an annotated version of the form with some sample defenses. For example, if you feel the landlord is evicting you because of retaliation, because you've made some complaints, or if you feel that the landlord is discriminating against you on the basis of race or gender or any other protected category, then that's another viable defense that could help you get the case dismissed. And so denials, you can assert all the denials on your answer form. If you think the landlord said you owed an incorrect amount, include that in your denials. You can deny any incorrect information. You also want to assert all the defenses in your answer form, and this might include commercial frustration of purpose. For example, the amount is much less because I had to be closed by government mandate and I shouldn't have to pay rent for all those months. The landlord, you might assert, the landlord told me that I don't have to pay rent for all the months of the pandemic, and I have that communication, and that's one of your defenses. You can also list the pandemic, just list that you got sick, that you couldn't operate your business, and in even the moratorium and the forbearance period itself. Some landlords are suing landlords for unpaid rent, including that which was accrued during the moratorium period. And when the business owner might be a tier 1 tenant and has 2 years to repay. So the landlord should not be evicting the tenant for the back rent accrued during this time. The landlord can, however, evict a tenant for failure to pay full rent after the moratorium expired beginning October 1st, 2021. So, but the amount that's listed might be incorrect. You just want to really look at all the allegations against you and deny them or assert defenses against the landlord. This will help put them on the defense. And then once your answer is submitted, then you can go back to negotiate and say, look, what you're asking for is completely unreasonable, and let's try to settle this outside of the courtroom. So again, these are sample defenses that I went over. There's an additional form, MC25, which will also send to you a sample of, and you can really elaborate on this form. Instead of just listing it on the UD 105, you can elaborate on your story and why you're asserting this defense. Many of our clients are eligible for fee waivers. There's different ways to determine that. If you're eligible for any type of benefit, usually you are eligible for a fee waiver, and it could cost $400 or $500 to file your answer and other court papers. So it's definitely worth applying for if you think you might be eligible. Also, you can just, the court will, on an individual basis, assess whether you have enough income to pay for your household's basic needs and the court fees. And if the answer is no, then you'll likely be eligible for a fee waiver. And these are the forms that you'll have to fill out. They're hyperlinked in the presentation that we'll send to you all. After you file your answer form, either party can file a request to set the case for trial. You might want to bring the case to court if you think you have really viable defenses. The landlord might want to proceed to a trial date. That's the next step in the eviction lawsuit. It usually is at least 20 days after either party files the request. It could be longer, especially now the courts might be delayed after the moratorium in processing a lot more lawsuits. This is the phase within the 20 days before the trial date has been set. You're going to want to collect evidence. Any communication with your landlord that implied that some of the rent is forgiven, you want to collect text messages, emails, any written notice, even voicemails can be saved as audio files, and you can present all of this evidence at your trial date. If your landlord is asking for evidence that you think is unreasonable, for example, if you're an LLC, the landlord is asking for your personal bank statements, that's irrelevant. You can object. You don't need to answer or give all of the pieces of evidence that are being requested of you. You can say they're asking for confidential information without the basis of showing the need for the information. An undue burden, you don't have all these documents that the landlord is asking for, and you can even object based on, this is harassing, annoyance, embarrassment, oppressive. So please do reference these possible objections if it's relevant, which we hope it's not. You have the option to call witnesses. Some tenants are asking other tenants of the same landlord what sort of rent repayment plans were offered to them. And then, seeing if it seems really subjective, in some cases discriminatory. Why aren't some tenants being offered as generous a rent forgiveness plan for really arbitrary reasons? That sort of witness might be really helpful before the court. And even on the day, if your case proceeds to trial, the judge will definitely ask you and the landlord to step outside and try to settle even on the day of your court case, of your trial date. So please just know that if you've been trying to negotiate with your landlord and then it doesn't seem to be working, even on the date of your trial, you still might have the chance to settle without getting evicted. And if you do settle your case, you don't want to leave the courtroom without a written copy. As many of you know, this has come up so much during the pandemic. The landlord says one thing, that they'll offer one thing, and then they don't follow through. So you just want to stay in the court till you have a written copy of the agreement. It will help prevent misunderstandings. But if your trial is heard before a judge, the judge made a decision. If the judge does rule in favor of the landlord to evict you, they'll issue a judgment of possession. They may also order you to pay the back rent, damages, penalties, and even attorney's costs if that's outlined in your lease. And the lease will contain those sort of provisions to look out for, that if you lose in a court case, are you required to pay the landlord's attorney's fees? And the final steps that you should just know about is that the landlord could issue, after the judgment of possession, they'll issue a writ of execution that the landlord will take to his sheriff's office. Only the sheriff has the right to lock you out, to change the keys. So the landlord does not at any point have this right. You'll get a notice to vacate, which gives you 5 days. You can request up to 40 days, an extension of that amount of time if you need more time to move out, but just be aware that you'll have to pay rent during that time if you are granted an extension. Okay, so it's time. I'm sorry I've gone a minute over, and for anyone who wants to stay on, if you have additional questions, I'd be happy to stay on, or please do apply for our services. We'll be sending all of these resources, including, this is a hyperlink to our services, or you can just Google LSC of LCCRSF. And these are links to Alameda County Self-Help Center, the different bar associations that offer sliding scale services. And if you're San Francisco client, commercial tenant, you also have the option of receiving free mediation services through conflict intervention services. Yeah, anyone who would like follow-up services, and please just apply for our services. And I'm including my personal email address, my work email address, as well as this is an email address that we've created specifically for commercial tenants to ask your questions, commercial.lease@lccrsf.org. Anyone else have any questions specific to your case, or just before you apply? But thank you so much for attending today. It's our honor to serve small businesses in the Bay Area, and we hope to hear from anyone who needs follow-up services. So I'll stop the share now and stop recording if anyone would like to stay on for a few more minutes. Thank you again for joining us.